Hi, hello everyone. Let us discuss Article 310 or qualified theft under revised penal code. But before that, let us take some review about the definition of theft under Article 308. So, the first element of this theft is that there be taking of personal property. As a review again, the personal property referred here are the movable properties defined under Article 416 of the Civil Code. An example of personal property is the first paragraph where movables susceptible of appropriation which are not included in the meaning of what are real properties are described in Article 416 as to the meaning of movables. Now, the second element of theft is that the said property belongs to another. Of course, a property may belong to you, it may belong to another, or it may belong to the state. But here we are only referring to properties belonging to another. Because if you have taken properties which eventually belong to you, for example, you have taken a pencil here in the table left by another person, thinking that it was another person, you took it with the intention to gain, but however, when you reach home, you have discovered that the pencil you have taken are actually your own pencil. So, that is an impossible crime under paragraph 2 of Article Revised Penal Code. The third paragraph or the third element of theft is that the taking be done with intent to gain. Take note of the term intent to gain, meaning theft is an intentional felony and it is committed only by means of deceit or dolo and cannot be committed by means of fault. So there is no culpable theft or culpable qualified theft. With that, we cannot say that there is reckless imprudence in theft. It just go against the grain. The fourth element is that the taking be done without the consent of the owner. Of course, because if the taking be done with the consent of owner, it will no longer be theft. It can be estafa or other cases or other felonies involving taking of personal properties. Now that the fifth element of theft is that the taking be accomplished without, take note the word without, the use of violence against or intimidation of persons or force upon things. Because if the taking is with the use of violence against or intimidation of persons, now the felony would be robbery. Now, what are then the circumstances which would make theft as a qualified theft? Where we'll discuss the circumstances of each. The first circumstance is that the theft is committed by a domestic servant. Yung mga kasama sa bahay. So, who then are domestic servants? Under the Labor Code of the Philippines, we have to infer that these are the domestics or household service as a service in the employer's home that provides convenience and personal comfort to the employer. So, example of that are domestic helpers, including maids, cooks, yayas, nannies, drivers, and all-around helpers. So, these are examples of your domestic servants. Another circumstance is that the theft is committed with grave abuse of confidence. Please take note of the word grave because this abuse of confidence can also be just a mere abuse of confidence. Grave is a higher level of abuse of confidence. So when can we consider that there is grave abuse of confidence? Well, there is grave abuse of confidence when there is arbitrary or despotic exercise of power. Despotic talaga, masama. Due to passion, prejudice, or personal hostility, or the whimsical, arbitrary, or capricious exercise of power that amounts to an evasion or refusal to perform a positive duty enjoined by law or to act at all in contemplation of law. Medyo matigas talagang ulo, no? Despotic. So let us take here some examples of cases where there is grave abuse of confidence between the owner of the thing and the person who took it. So, in the case of People versus Coxon here, it says the Supreme Court said that the allegation in the information and proof of a relation by reason of dependence, guardianship, or vigilance when the accused and the offended party that has created high degree of confidence between them. So meaning here, the relation, it is the relation and between the parties, like for example, guardianship, dependence, or vigilance, magkalapit talaga. And this relationship must also be alleged in the information to say that there is really a grave abuse of discretion. Now, in the case of People versus Lingat, here, an example where there is grave abuse of confidence is that when the accused was permitted to sleep in the house of the offended party out of charity. Pinatulog out of charity, nanakawan ka. Another example is in the case of People versus Yoho. Here, the accused, the person who sheltered the accused out of charity. Then, after being sheltered out of charity, the accused took the money belonging to the person who protected him. This also aggravated the felony because there is presence of grave abuse of confidence. Then, if there is presence of grave abuse of confidence in the above cases, when then can we say that the accused did not act with grave abuse of confidence? In the case of People versus Malaya here, there is no grave abuse of confidence because here the employer had never given him the possession of the machines involved or allowed him to take hold of them. It does not appear that the former had any special confidence in him. So ito yung mga kinikilos nito ng employer here would say that there is no confidence towards the person who took the machine. So there is no grave abuse of discretion. Again, in the case of People versus Coxon here, the fact here constitutes the term here, housemate, would not necessarily mean that there is always a level of confidence. Housemate here, but the housemate ni Kuya? Baka siguro here, the housemate here was only performing a minimal task. Maybe he was not allowed or she was not allowed free roaming inside the house of the employer. So here, the level of confidence is low. In the case of People versus De La Cruz, here, the fact of living together in the same house may be accidental, and the goods stolen at night might not have been entrusted to the custody or vigilance of the accused. So accidental na pag-stay. And another example here is that the laborer here, where the theft committed, does not necessarily mean that there is a relationship just because you are a laborer. So there are two instances here, laborer and housemates, where the Supreme Court held that there was no level of confidence in the relationship. Another circumstance is that when the property is stolen is either a motor vehicle, male matter, or large cattle. Motor vehicle must be motorized, male matter, mga hinuhulog ng mga sulat, or large cattle. Well, what is a large cattle? Is there a small cattle? Under PD 533 or 19 series of 1974, the Anti-Cattle Rustling Law of 1974 describes large cattle to include the cow, carabao, horse, mule, ass, or other domesticated member of the bovine family. So what are bovine family? This refers to domestic animals of the species of both taurus cattle or bubalis, water buffalo, and also includes hybrids like buffalo. So any of this, you steal any of this large cattle animal, you are liable under the felony of qualified theft. You will be liable to the felony of qualified theft. Another circumstance is that the property stolen consists of coconuts taken from the premises of plantation. Actually, with the advent of PD 330, series of 1973, timber also is included here because in PD 332, it penalizes timber smuggling or illegal cutting of logs from public forests and forest reserves as qualified theft. The fifth element of the fifth circumstance which would qualify theft is that the property stolen is fish taken from a fish pond or fishery. Because here, fish pond or fishery, there are both private properties. However, if you just take fish in public rivers or seas dagat, there is no qualified theft because those are properties belonging to the government unlimited. Ang pagkuha ng isda, sa sixth circumstance is that the property was taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance. Actually, this one is very common, yung the term earthquake, typhoon, because last time, they looted an appliance center. Sabi nila, nagutom daw sila. That's why they looted the appliance center during the Typhoon Pablo. I just can't imagine how the TV can erase their hunger. Also, in the US now, during COVID times, I just saw in Facebook that an entire department store was looted during the COVID. Another here is yung vehicular accident. We have also seen in Facebook where truck natumba siya in the road and the people there took away the mga beer, mga alcoholic beverage in the San Miguel na natumba sa kalsada. So that's a vehicular accident. That's also qualified theft. Now, there's another question here we have to answer. Should full ownership of the thing stolen need to be established before the accused could be convicted of qualified theft? Kailangan mo talaga malaman kung sino ang may-ari. Well, in the case of People versus Mercado here, the Supreme Court said that the definition of theft is that the property taken does not belong to the accused or it belongs to another person. So therefore, it is a material whether said offender stole it from the owner. Because here, the matter of the property belonging to the accused is a defense. So if you are able to prove that what you have taken is your own personal property, it's a defense on your part. Therefore, there is no theft here. So, in any event, as stated above, the factual findings of the courts as though the ownership of the amount petitioner stole is conclusive. Next, in the case also of People versus Mercado here, the determination of the penalty for qualified theft is taken as to the value of the property stolen. So meaning, the higher the value of the property that is stolen, of course, the higher is the penalty. And talking about penalty, the penalty for theft is already amended under Republic Act 10951. Mataas na siya. There, only theft was described under Section 81. It says there, any person guilty of theft shall be punished by penalty of prison mayor in its minimum period if the value of the thing is stolen is more than 1 million. So here, there's a value of the property. There is a graduation of the penalty there. So, with even that even though qualified theft is not mentioned in RA 10951, but since theft is mentioned therein, it follows that the provision also refers to qualified theft. With that, let us now listen to the court case of Clark Ingles as to qualified theft.